Hi guys, it's Kathy. I hope you're doing well. Yeah, yeah, I got sick. This is the first time I've been out of my room since Sunday when I got off work. I couldn't, I couldn't get downstairs. Well, I did. Every time I needed something more to drink, I had to come downstairs. But yeah, this sucks. Anyway, anyway, we're gonna start today. Oh, I didn't share my screen. We're gonna start today with something for Fozzie. There. Please say there's
Who's here
sound.
for Stevenson? Ben. Okay.
Is he here for Stevenson? Okay, no. All right.
Are you here for Stevenson?
No, I'm here for Jeremiah White now.
Okay.
So I'm not sure why they put the numbers.
All right.
Oh, keep separate. So no 15.
I couldn't. When I got this Fozzie, I'm like, is that Judge Van? I can't see very well. Sort of looks like Judge Van. Sounds like Judge Van. I better ask Kelly. So I had to ask Kelly. Kelly, is this Judge Van? And Kelly is like, yep, that's Judge Van and the gorgeous sheriff.
I know.
I don't. No.
He's on that string. Oh, I can't. All right, you ready, Miss Pembroke?
Yes.
All right, state your name, sir.
Frankie Nelson Stevens.
Mr. Stevenson, you're full court charged of possession of child sexual conduct pornography. You understand that charge?
Yes, sir.
I understand you've been given copies of paperwork advised of your rights. Is that true?
Yes, sir.
Based on your application, you do not qualify for a public defender, but the law recognizes your financial situation may change, in which case you can reapply later. You also have the option of hiring your own attorney or
Thank you,
represent yourself.
Maria.
Any question about these options?
No, sir.
Deputy, criminal history, Mr. Stevenson?
Shows no history.
Mr. Stevenson, bond is set at $100,000. No contact with the alleged victim or anyone under the age of 18. No contact or no access to internet. Court date's going to be February the 17th at 9 o'clock. Good luck, sir.
Steps to your right to the T. When the green light comes on, sign. Sir, give us a moment, please. Here you go. State your name, sir.
Zachary Lowry.
Court for attempted murder, including, you understand the charges?
Broke up.
It's charged with attempted murder and fleeing and eluding.
Yes, sir.
I understand you've been given copies of paperwork and advised of your rights. Is that true?
Yes, sir.
Based on your application, I find that you do qualify. I'm going to go ahead and appoint the public defender to represent you. Any question about that?
No, sir.
Deputy, criminal history?
Had domestic, same victim back in November. You have a criminal mischief out of Colorado in 14. That's it.
Bond set at 150,000 on the attempted murder, 25,000 on the flee and eluding. Court date's going to be February the 13th at 9 o'clock. No contact, directly, indirectly, or through a third party alleged victim.
All right, step to your right to the T. When the green light comes on, sign. Next. Red X, sir. State your name.
Mr. Bush, you're fully court on violation of probation for charges that were originally in front of Judge Stevenson. You understand that, sir?
Yes, sir.
Based on your application, since you do qualify, I'm going to go ahead and appoint the public defender to represent you. So you have an attorney now. Judge Stevenson, in his infinite wisdom, is where you held without bond. Your court date's going to be February the 26th at 9 o'clock. It's a late date, February 26th.
Step behind him at the signature pad. Next. Red X, sir. State your name.
Stephen Lyons.
Shalon, before the court on a violation of probation for what was originally disorderly conduct and resisting officer without violence. You understand the charges?
Yes, sir.
All right, sir. What did you hear from Mr. Lyons? Let Tom.
Your Honor, he was arrested on a felony charge of sex offender registration requirements. I think you had that first appearance here the other day instead of bond. I think it's $5,500.
5,000.
Yeah. And so, wanted to let you know that this VOP is in front of you, this misdemeanor VOP.
It's my vehicle.
Video. And he was done with his probation. He was set to be terminated on February 7th.
Well, you know the problem with that.
Yeah, I mean, he got the new charge.
Right. That's a violation.
But looking at the application complaint of the registration, they're saying he cannot be confirmed that he lived there. I guess they went by the time to knock on the door. And then the uncle said, well, he doesn't live here. Well, the uncle doesn't even live there. So I would just ask, move on this. Let us get it sorted out. We can come on I think we're set for this on the 5th of February, maybe 4th or 5th of February. I just hate for him to sit in jail for a month, costing county $60 a day.
No, we're okay with that. Don't worry about that.
The county's got the money.
County's got the money.
Okay.
I don't mind.
Yeah, I know.
I don't mind spending their money since it's my VOP.
But he has done all his conditions. He's done everything he's supposed to.
What did it start off as? Because there's no way I put him on probation for disorderly conduct. Well,
I did not represent him, so
did it start off as something else? Had to have.
I think it was a felony. It was dropped, and that's how he got suspended because I was mad that I was like, 60 on you? That's the one from yesterday.
Suspended sentence, though, from felony. It's a 60-day suspended sentence.
I don't know, Judge. I didn't represent him. So.
It's not it can't be my sentence because I would have never done, first of all, I would have never handcuffed myself to 60 days only because I'm not that way. And second of all,
I love him.
well, the resisting isn't. See, so I would have never handcuffed myself on a resisting. So this is a circuit judge that decided to waive it down with a suspended sentence on a VOP. Oh, yeah, I don't know. Well, I mean, I hate for him to come back and have to do 60 more days. I mean, 30, 50, 45 more days. He's getting game time this way. I don't know what's better for him. You see what I mean?
I completely understand the position.
I just don't want, I think it's better off for him to do it straight because then he has 40 days and he's over. He's got there's a suspended sentence. So that was my.
Mr. Lyons, it's honestly, it'd be better if you just sit in there till your VOP day because you got a suspended sentence. And
I can give you credit and I can treat it like you get game time when we see you on February 5th.
Well, the VOP wouldn't be a VOP, Your Honor, if that the address would have been taken care of.
Yeah, you're right.
I live there. Everything. He has all the evidence. Everything. All the paperwork. My uncle lives in 321. I live in 323 with my dad. I've been there ever since I got out of prison. In April, nothing has changed. Everything. My driver's license, my bank account, my jobs. I just came to register with the sheriff's office on 11/6 and reported to probation on 12/6, and they said that I was avoiding them. They had my phone number. I just went to the sheriff's office. Like there is no reason why I should have a violation of a failure for an address, Your Honor. Yes.
Your attorney's telling you to shut up.
Yes, sir. I can barely hear. I'm sorry, I can't.
He has the ability. He has the right, but not the ability. Yeah.
that his uncle does not live at the residence. He lives
Okay.
next door.
All right.
And I have been provided documentation from his fiance showing the bank accounts and all are at that address. But we, of course, don't know what's going to happen at an evidentiary hearing. And,
Yeah.
You know,
I mean, I'd hate to let him out and then have to go back. I mean, and I can do more with it if I got time to play with it when I see him on the 5th. Because it's not my sentence. So I'm going to hold him. And then we'll resolve it on the 2nd, on February 5th.
okay. Thank you, Judge.
We can resolve it on February 5th completely. Well, no, not, I mean, there's something squirrely going on. I don't know. But we can.
I'll be out to see you next week, okay? I'll put you on my
Hey,
station.
if something changes, let me know.
Okay, I'm gonna get it with Bill. Thank you, Judge.
Yep.
Up to your right to the T. When the green light comes on, sign. Next,
No, you had a
red
jacket.
X, state your name.
I thought I was overselling myself that way.
You did. You did oversell. State your name for me, sir.
Jeremiah White.
Mr. White, you're for the court charged with driving under the influence. You understand that charge?
Yes, sir.
I understand you've been given copies of paperwork and advised of your rights. Is that true?
Yes, sir.
Mr. Dogle.
Judge, his friend is here and is going to help him out. I guess he's in the wheelchair, he can't walk. He had stage 4 cancer at some point, so maybe that's what the issue is. But apparently, health-wise, he's doing much better from his friend. But his friend's been willing to help him out, do those type of things. It's going to help bond him out. I'm not aware if he has any kind of prior record, Judge.
Deputy?
Kentucky Strangulation 21, FTA 6, 7, 16, and 8. 14, Grand Theft Auto, para, controlled substance, sale of marijuana, DWLSR, and 16. That's it.
Only 3 failures to appear.
And he hasn't had anything in 4 years.
Had a boy.
4 years.
Bond's 5,000. Court date's going to be January the 8th at 8:30. No alcohol while you're on release, buddy. Good luck.
Can't slide over to the T? Yes, sir. When the green light comes on, you can sign for a copy. You got to back up to the T.
Get in one.
There you go. And that signature pad, the light's going to come on in a minute. Wait for the light. Red X, ma'am.
Good.
State your name.
Is this Miss Taylor?
Yes, sir.
And before the court charged with an out-of-county warrant. It's out of Gadsden County for violation of probation. You understand that, ma'am?
Yes, sir.
All right. Your Judge Fleury out of Gadsden County has set a $2,500 bond on you. Can you make that?
I can try.
Okay. I guess that's about all I can ask of you. So
Yes.
the bond's in place. If you can make that, we will release you, and then it's up to you to make your way to Gadsden County and make your court date, okay?
Yes, sir.
Otherwise, we're going to have you returnable to a first appearance judge here if you haven't been transported by January the 21st.
Yes, sir.
Good luck, Ms. Taylor.
All right. Step to your right to the T. When the green light comes on, sign. Next, red X,
weird.
ma'am. There you go. State your name.
Weaver.
Ms. Weaver, you fully court charged with violation of pretrial conditional release for domestic violence. You understand that charge?
Yes, sir.
I understand you've been given copies of paperwork and advised of your rights. That's true?
Yes, sir.
Based on your application, once you do qualify, I'm going to go ahead and appoint the public defender to represent you. Any question about that?
No, sir.
Deputy, criminal history?
She actually has a bond on a felony case, and she didn't make it on the same
It's his first day. First day.
victim.
Was she violated no contact from jail?
Yes, sir.
That's pretty impressive. What was that felony case number?
24-4146 CF.
I mean, nothing like making sure.
In about 2 minutes, Judge Van is going to do what Judge Van always does.
All right, Mr. Beaver, on the violation conditional release, bonds 5,000, no contact with alleged victim, and I am revoking your bond that you haven't even made yet in 24/41/46. Good luck, ma'am.
Step on the T. When the green light comes on, sign. Red X, ma'am. State your name.
Sarah King.
There you go.
King, you're fully court charged with resisting officer without violence and battery. Do you understand those charges?
Yes, sir.
I understand you've been given copies of paperwork and advised of your rights. That's true, ma'am?
Yeah.
Based on your application, I find you do qualify for the services of the public defender's office. I'm going to go ahead and appoint the public defender to represent you. Any question about that?
No.
Deputy, criminal history?
Battery 23, battery second 19, disorderly para VOP, 18 domestic, 17 battery, 16 child abuse without harm. It goes back to the 90s with another battery.
Bonds 2,500 on the resisting, 5,000 on the battery. No contact, directly, indirectly, or through a third party alleged victim. Court date is January the 8th at 8:30.
All right, step to your right to the T. When the green light comes on, sign. Next. When the light comes on. Step on the X. State your name.
Belinda Herrick.
Ms. Herrick, you're fully court charged with operating a motor vehicle.
And that's what Judge Van does to you. Right when you're in it and you're ready, it's like we're married. You're really enjoying yourself, and then all of a sudden, oh, what? It's over? That sucks. I wanted more. Oh well. So I haven't been to this next court in a while because all they ever do is let people out. They just let people out. So, I go every once in a while and I watch her because I love her. But I decided to check it out again. She's not there. I don't know if it's just the one day that she's not there or if this is a new guy in town. But in my head, right now, since we have no other information before us, there's a new guy in town. I tried to bump up the sound. You're either going to hear this or not. If you don't hear it, fine. I'll turn it off. Just let me know. Well, no one's speaking now, so you can't hear anything right now. And, okay, that's not normal. Cage might be new to a bunch of you. But we're used to the cage here. But what's not normal is normally all the inmates come in for this. Not the officers come in with one inmate. So right away I knew something was this guy's causing a lot of problems in the jail. This is like it's only a 3-minute video and it doesn't get to where we wanted to get to until the end.
All right, it's Justin Tyler Vance, your incorrect name. Correct, Your Honor. All right, thank you. You're here on case 25 FE 000129, offense date of December 31st, 2024. Count 1 alleges a violation of paper 459 burglary. There's also allegations of paper 65.5C.
This is Sacramento, California. And they always have the cage here. So apparently this is a door, but you can't get out the door because they have this great big wooden thing across it. But this door is not locked. The door to the cage is not locked. They're not locked in the cage for hours and hours. Sometimes like 10 of them will come out and they'll all stand in this little cage, while they go through each one. But none of them are locked in a cage for court. But they're not allowed to come out. This is not normal. They usually stand right next to them and talk to them. He won't go anywhere near him. And there's 2 armed guards. Now, we had this guy once before where the guards wheeled him in on a dolly. He was strapped to a dolly and he was restrained. And the guards had a they wheeled him in and he came in and he started swearing at and yelling at the other judge. Do you remember her? I can't remember her name off the top of my head. With the real long brown hair. Anyway, he was insane. It was just like what was that movie with Clarice? Remember how they went to the airport and they wheeled him out in the airport? That's exactly what happened, only he didn't have one of those masks on.
1, 1202.1, 462A, count 2 is a violation of Penal Code 594A, vandalism. Count 3 is an allegation of Penal Code 148A1, resisting arrest. The public defender is appointed.
Federal records have been appointed, Your Honor, for a formal arraignment with the rights. At this time, I have the discovery and the complaints on this matter. Your Honor, at this time, we would like to set this matter for a preliminary hearing. We are requesting day 8 of 10, which is January 16th, 5, day 10 of 10 to January 5. I believe this should be an 8:31 or is this a 1:30?
I think it's 8:30. This one, I think, by 10 days, January 21st. Now,
January 16th?
or, excuse me, well, I'm actually trying for the 10 day of January.
I thought you said the 8. My apologies.
That's 60th.
I know the audio in this court sucks.
Are the other matters to trail this one?
Yes, Your Honor.
Okay, and then Ms. Salata, I need to ask, is he on pretrial release in the other pending cases, case ending 272 or 227?
I will double check which case, but I do believe he is on pretrial release on at least one of those matters. If you just give me one moment, I can tell you what the case number is.
And I love her. She fights so hard. And the last judge just let everybody go. She's like, no, we cannot give him a bond. We cannot. This is why. She was just like 30 crimes, and the last judge would be like, yeah, okay, I'm going to release you. You better listen. But I got another one coming too from this court with her. She's so good.
In case ending 272, it looks like he was on pretrial release. So I'd ask that that be revoked if it had already been revoked. And then in the case ending 227, I'm just looking to see what he was out on. It looks like he was released on his own recognizance on the misdemeanor 227.
Okay, so the case is set for preliminary hearing January 16, 2025, Department 9, 8:30 a.m. That's for this case ending 129. Both other cases, felony and misdemeanor, are to trail. And today is January 21st, 2025, 60th day, March 7th, 2025. Pretrial release in felony case ending 272 is revoked. I'm going to set that in that case at no bail.
I'm going to honor in light of that. I will request that be without prejudice.
No bail without prejudice in that case, in case the matter is taken up. Thank you, Mr. Rick.
Can I say something?
I wouldn't know if the case is going to.
I'm right to be violated. I'm not being that out of myself at all, sir. I'll bet my what being violated, my food being struck, I've been an hour myself.
He's causing problems in there. Now, here, watch her. Watch her fight hard. And the last judge, it wouldn't go very well for her.
What's that, Brad? Okay, thank you.
This one you can hear better.
Wife, Mr. Valencia, in custody before the court.
Okay, so you've been retained. All right, this is case 25. Oh, and I should ask, Mr. Valencia, did Nancy or Valencia your true and correct name? All right, thank you. This is case 25 F2000, Penn State, January 2nd, 2025. Count one alleged violation of Penal Code 2900A1, possession of a firearm by a person. There is a prior strike allegation. Count two is a violation of Vehicle Code 2800.2 and evading a police officer while driving in a reckless manner. And that also comes with a strike prior allegation. Ms. White has been.
Thank you, Your Honor. I'll acknowledge receipt of the felony complaint, and I also have a copy of the initial discovery from the clerk's office, so thank you. Mr. Valencia has an open docket that pre-exists this docket. The court never set bail on that original docket. He bailed out from the jail, which he was arrested under essentially different circumstances than the DA was charging. So at this time, we're just asked the court will set bail as per schedule for both cases.
I'm going to ask that bail remain set at no bail. This individual has a case pending on January 15th. If counsel would like to notice bail for that day, I think that would be the most appropriate date.
So before she goes any further, a 2800 is a gun charge. A 2802 is evading the police.
Both matters can be heard on that day. That matter is a 29800 for the court's information. That is set in Department 62 on January 15th at 8:30. This is a new 29800 as well as a 2800.2. He has an extensive history of firearms possession as well as felony evading. He was out on bail when he picked up this new 2800 and 2800.2. Very serious evading as well as possession of a 9mm pistol. Based on all of his history and the other case pending, I think the most appropriate thing to do at this point is notice bail for the next court date.
If I may, I do think that my client is constitutionally entitled to bail for these particular charges. I'm not asking for an argument below schedule or to make some sort of change based on facts and circumstances, but I do think he's entitled to set amount.
Okay, Ms. Lonnie, any response to that?
Yes, I would ask that the court again remain at no bail. I think he's a danger to the public. If the court is inclined to set bail, I think that would endanger the public. He, in this new matter, again, was out on bail on a gun case. He sped away from officers when they attempted to contact him at a high rate of speed. He was going 80 miles per hour in a 25 mile per hour zone. He passed cars in opposing lanes of traffic. He ran 4 stop signs. He ignored traffic signs. He crashed his car into a tree. He fled on foot from law enforcement. And during that evasion from law enforcement, he discarded a 9mm pistol. Again, he's pending a 29800 case that he was out on bail on. He has a history of 29800. He has a 29800 from 2021. It's a 4-year state prison commitment. He has a 2800.2. So he has a prior evading from 2017, 3-year state prison. He has a 245A1 prior in 2009, 4-year state prison. He has a 29800 in 2013 for 5 years, 8 months. That's his prior strike. It also has a 186.22 allegation, a gang enhancement. So this individual has a very serious criminal history, extensive history with gun possession. He has a prior evading. He's back here evading officers with a gun while he's out on bail for a gun. This individual poses a significant risk to public safety. There is no combination or condition of release that would ensure public safety. I'm asking it remain at no bail.
Yes.
I think that ultimately, I understand the people's position, and Mr. Valencia acknowledges that he has history. I will note that the strike offense that's alleged in the complaint is from 2013, it's 12 years ago. the striking by way of enhancement as a gun possession charge. There's a reason that the Constitution specifies certain crimes that are exempt from the normal bail analysis. For the crimes that the people chose to charge here, they're listed on the bail schedule. There is nothing that stands out, I think, in my mind, despite the laundry list of history, that would differentiate Mr. Valencia from other individuals under similar circumstances who are just asking for scheduled bail to be set for 2 open cases. Once again, I'm not trying to, all I'm asking is the court to do what is legally required to do, which is to set a monetary bail in this circumstance. Should that amount be too much and we request a comprehensive analysis of all of that, then we can do that in a notice of bail motion, but it's arraignment. And Mr. Valencia is simply asking the court, I believe at schedule, at 2,800 is 50,000. The evading is another 50. The out on bail enhancement is 75. And there is a dollar amount that we can come to that I think makes statutory sense here. Without having to go into extensive detail, I'm just asking based on what's been charged for the court to set bail.
Counsel asking for a bail motion, the court can consider public safety first and foremost and set no bail.
Okay. So, Ms. White, here is where I'm at. Based on the recitation of the facts of the case, the history, and everything that I've heard from both sides, I'm not prepared to deviate from the no bail hold in this case right now, especially given the fact that he was on bail in another case. I can give you 2 options. One is to come back for a fuller hearing with notice bail on the 15th for another 4 cases scheduled. Otherwise, I would proceed to make findings now.
No, I'll have to come back for a full notice hearing. If we could come back, we're good.
Department 62, I believe, is where you were.
It's a shame that you get to see her because the other defense attorney, every single time I get this court, I watch this court or whatever, she is a clothes horse. She wears the greatest outfits and they always drip. They look perfect on her. I could just show a clip of her, what she's wearing every day to start our stream. What is she wearing today? Because it's always perfect.
It's currently set for January 15th at 8:30 in Department 62.
We'll put it all
Okay, so we can try to put a notice bail motion. All right, notice bail motion. Ms. Salado, what was the bail set at in case ending 255?
I believe it had previously been set at $1 million.
Okay. So the bond is revoked in that case.
Thank you.
Okay, thank you, Ms. White.
Thank you.
Returning to.
So she finally gets people who don't get a bond or get just a ridiculously high bond. So her job got a whole lot better today. Oh, Monica, thank you. I haven't seen this court in a while, so I just don't know if this is a new guy in town or not. I'm going to find out though, don't worry. Or not, who knows. I'm missing 3 clips, but that's okay. That's okay. That's okay. Did I show you guys this one? I'll just do this one instead. I don't think I showed you guys this one.
Hear from you, because the problem is I can't appoint another public defender if the reason is that you're not cooperating.
No, Your Honor. I just in the last 2 years of just like.
Would you move the microphone down, because I need to make sure I have you on the record.
Okay. Just like in the last 2 years of just the family division and all that, and just getting back on my feet and just having like health problems and stuff like that, and also family members with health problems. I've unfortunately have not been able to just really put my energy into that. My energy has been going into taking care of my daughter, getting her to school, just, getting a new.
Did I show her? Did I show her? Okay, hold on. I got a different clip then. Do not worry. Do not worry. So, I want to tell you about this clip, but I can't remember what I want to tell you. So I'm going to start it and then pause it like I always do.
I will begin by introducing the panel. I am Judge W.C. Kirkendall from Seguin. I'm the chair of BOTA, and I'll be presiding over today's hearing. Joining me are the vice chair, Jason Boatwright from Dallas. Jason, would you wave your hand?
Now I remember. Okay, this is a disciplinary hearing for a bad attorney. We're going to get to hear her speak. She might be crazy. I'm not sure. We're going to find out. But we get to hear them be all lawyerly first. And, lawyer. And then we get to hear her. She's great when she's talking.
And so the parties can recognize you. And board member Arthur DeAndrea, who lives in Lubbock. Arthur, thank you. BOTA staff are also present in this Zoom meeting. We have provided counsel and parties with a set of instructions and guidance for remote hearings, as well as instructions and guidelines for BOTA proceeding generally. We expect that you have reviewed these instructions and are prepared to comply with them. A few brief reminders. The board has instructed the parties and counsel to submit electronic files of any potential exhibits in advance. Those exhibits are not yet in evidence. They must be offered into evidence and admitted by the chair in order to be considered and made a part of the record. If you wish to offer an exhibit that was not submitted previously, you must request leave to do so. We have screen sharing available on this Zoom call. You may request authorization to use screen sharing to display exhibits after they've been admitted, but the document shared must be identical to the document in the record. We also have breakout rooms available, and you may use a breakout room to confer privately. Breakout room discussions cannot be seen or heard by the board, and they will not be recorded or live streamed. You may make use of Zoom's private chat feature, except that counsel and parties may not use the chat to communicate with witnesses about their testimony. Please do not upload or share any files through chat unless invited to do so by the chair. Please do not message board members through chat. BOTA will not record or retain any chat messages.
They put that one in because of me.
Remember that Zoom will pick up any background noise, so please silence any notifications on your device. And please, if you have a dog in your room, please silence that dog too. Before speaking, please make sure you're not muted. Any pro se party wishing to present testimony must be sworn in as a witness.
Notice he didn't even try to say silence your cats. He didn't even try it.
And subject to cross-examination. We do have a court reporter present, and she is making the only official record of today's proceedings. We're now ready to proceed with today's hearings. Call case number 69924 in the matter of Tara Eden Latus, a reciprocal discipline case. Would the parties and counsel state your appearance for the record, Mr. Hunt Palmer?
Yes, thank you, Mr. Chair. Richard Hunt Palmer for petitioner.
All right, and the respondent, please.
Tara Latus, the respondent, pro se.
All right. Are you ready, Mr. Hunt Palmer?
Yes, Mr. Chair.
You originally indicated you wanted about 5 minutes to present your case. Is that still correct?
Yes, it might go to 7, but that is still correct.
We'll give you that much latitude. Do you intend to call any witnesses?
No, you're Mr. Chair.
Ms. Latus?
My son is currently in the great state of Texas. So I was not feeling good. I couldn't move. My son flies to Texas the day I get sick and immediately is lost. We get this text message saying that So he had a plane from Philadelphia to Houston, Houston to Dallas. Okay? He made it to Houston, and then all the planes to Dallas were canceled because of the weather. So he's stuck in Houston. I still don't know how he made it to Dallas because his phone died and he did not charge it. So, like, 24 hours go by and I haven't heard from my son at all. And there's nothing I can do. His phone is not on, so I can't do anything to help him. I can't just like send him money if he needs money because his phone is not on. So I don't know if his plane from Houston to Dallas ever got rescheduled or anything. So I made a phone call to someone I know that might be able to, who lives in Texas and knows about airplanes, to see if he could tell me if my son's other plane that got canceled was redone or anything. But before that person could call me back, I finally got a hold of my son like a day and a half or more after he left. And the way I got a hold of him was, it just is bad and worse and worse. So when I couldn't take it anymore, I went to my son's computer and I opened his Discord. And I started texting everybody on his list. Okay? Now, if you could imagine someone going into my private messages and texting every single person on the list, but so when I did that, I missed a few important clues because I did finally find him at a girl's house. And supposedly he was going to Texas for an Overwatch tournament, to play in a tournament with his team. When I found out he was at a girl's house, I immediately assumed that he lied about everything and it was his girlfriend, right? So so this is what I sent her, thinking this was his girlfriend, and he lied to me, and I couldn't find him. This is what I sent her. All right. So she's like, "Here's my phone number. He's here with me. He's safe. He's fine. Here's my phone number. Until we get his phone charged, you can reach him through me." I said, "Okay. Hi, this is Anthony's mom. Let him know his anal bleach kit came in, but it's not compatible with his AIDS meds." Thinking this is his girlfriend that he never told me about. Right? Well, then, the next day I wasn't done. I was so mad. You guys don't even know how mad I was. So I sent this. She said, "We're going to get Anthony's phone fixed later today when I'm done with work. He's using my PC. If you need to reach him, you can send me messages." I said, "Bet." I said, "Okay. I don't need to talk to him, but thank you so much. Please ask him to call his son when he can because his son is worried." No, he does. He does not have a son. But I thought that was his girlfriend, that he lied to me, that he's in Texas and there's no Overwatch tournaments, right? Well, guess what, guys? That was not his girlfriend. That was the coach. He really is. He really is in Texas for a tournament. He didn't lie. He didn't lie to me. So I guess I'm gonna have to apologize to this woman later. Oh yeah, he loves me. Of course he's speaking to me. Of course he's speaking to me. He needs more money to get home now. All right. I don't gotta trust my son. I'm not stupid. What do you mean you gotta trust your son? Don't you have children? Of course you don't trust your kids. If you trust your kids, they'll do drugs. All right, where were we? We're going back to this crazy woman. Yeah. All right. Court.
Yes, are you as the respondent ready to proceed?
Yes, sir.
Do you have any estimate of how much time you need to present your case?
I really don't know. Maybe 5 minutes. I'm not really sure exactly about what I'll be asked and everything.
Do you intend to call any witnesses?
No, just speak for myself.
You intend to testify?
I'm not, I apologize. I'm not a litigator, so I mean, I don't mind being sworn in and everything being under oath, or if that's what it means.
She's
So
a
if you're
lawyer.
going to tell us anything that happened to you, you need to be under oath.
Then yes, sir.
That woman who just said those words is a lawyer, guys.
All right. Would you raise your right hand? Do you solemnly swear or affirm that any testimony you may give in this cause will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. Thank you. Do you have any other witnesses?
No, sir.
All right. I'll remind the parties this is a reciprocal discipline matter, which is an evidentiary hearing under the Texas Rules of Disciplinary Procedure. The commission bears the burden of proof, and the respondent must prove any defenses raised by her pleadings, and they must be proved by clear and convincing evidence. All right, Mr. M. Palmer, do you wish to make any opening statement, or would you prefer to go directly to your evidentiary presentation?
Mr. Chair, I can go directly to my presentation.
All right, you may proceed.
Thank you, and may it please the board. This is a reciprocal disciplinary matter brought pursuant to Part 9 of the Texas Rules of Disciplinary Procedure. The case is predicated upon a stipulation to discipline pursuant to CRCP 242.19. That's out of the state of Colorado. A certified copy is attached to Exhibit 1. I'll move to admit that into evidence shortly. It's also predicated upon an order approving stipulation to discipline under CRCP 242.19C that has been previously marked
I'm not in the doghouse. I'm the mom. I can't be in the doghouse.
and submitted as Exhibit 2 for petitioner. And finally, it's predicated upon the affidavit of Blake Hawthorne attesting to Miscellaneous's licensure to practice in Texas, which is currently inactive. At this time, with those three exhibits, I'd like to go ahead and move before I proceed to enter them into evidence as Exhibits 1 through 3.
All right. Do you have any objection, Ms. Latus?
No, sir.
All right. 1 through 3 are admitted.
Thank you. Under Part 9, through Exhibits 1, 2, and 3, the petition both establishes this court's jurisdiction to hear this matter, and it establishes its burden of proof to show that reciprocal discipline is warranted in this matter. Ms. Latus received a 3-year suspension in Colorado. The rules that are cited in Colorado are of the same kind and quality here in Texas. There's no reason that the imposition of identical discipline, a 3-year suspension, is unwarranted based on either the rules underlying her suspension or on any of the procedures. Ms. Latus, in her response and in her exhibits A through E, provides 4 primary reasons why reciprocal discipline is not warranted in this matter. I'd like to briefly discuss those and why they do not meet her burden of proof, which is clear and convincing evidence to establish any defense under Rule 9.04 of the TRDP. So the first point she raises, really the first 3, deal with, and this is in her response, they deal with the kind of underlying situation that led to her sanctions. First is that she claims that her clients filed objectively false affidavits with Colorado in support of their complaint against her. She asserts that her clients made extortionistic threats against her through emails and through the complaint process itself. And she argues that the Assistant Regulation Council provided the false affidavits to the Colorado Supreme Court, knowing full well that they made material false representations.
And today I learned men knew what reciprocal meant.
She doesn't tie any of these three in her response to a particular defense under 9.04, though she does note in her fourth point that she did not receive due process. They may be considered under that, but I don't think that they fall under any particular category. And the primary reason is that she stipulated to her discipline. She does say in her response that she has a complaint against the attorney for that process that is still, I believe, pending in Colorado. The fact that that has not been adjudicated or resolved is further reason that this board, well, that Ms. Latis cannot meet her burden to show any defense under 9.04. I would like to address her due process argument. She makes three. The first is that her personal circumstances and her mental health records, they were initially not considered during the settlement and the process of her discipline. She also notes that the Assistant Regulation Council refused to even consider some of the stipulations she was willing to make towards a lesser sanction. Now, both of those considerations are disposed of by the Exhibit E that respondent provides along with her response to be considered into evidence. That exhibit is a list of stipulations. It's Exhibit 2 to the stipulations that were provided to the court to support the stipulated discipline. And they note that as mitigating factors, her personal circumstances and mental health were considered in the discipline process. Finally, for the due process argument she makes, she notes that the Assistant Regulatory Council refused to depose her clients or call them as witnesses. And I believe that doesn't really apply because in her stipulation to discipline, she waived her right to a hearing. But in any case, due process wouldn't require that a prosecuting attorney, civil or criminal, depose or call witnesses that the opposing party defendant could call or depose. For all those reasons, Ms. Latis is not.
She's not the type of crazy that you want to stay away from. She's the kind that you guys all want to go towards. Just run towards this type of crazy.
Met her burden to show by clear and convincing evidence that any defense under Rule 9.04 applies, and therefore reciprocal discipline is warranted in this matter. That's all. Thank you, Mr. Chair.
What sanction are you requesting, Mr. Hunt Palmer?
Well, the identical discipline in this case would be a 3-year suspension, Mr. Chair.
Any questions of CDC representative?
I have one, Mr. Hunt Palmer. What's the Texas analog of the Colorado rule? I believe it's 1.15A and 1.15B that she was adjudged to have violated.
It's the failure to put funds into, well, let me double check this, but from my notes off the top of my head, it's...
Don't worry, the lawyers are almost done talking, but did anybody notice how Bren has been picking on Fozzie the whole time? And as soon as Bobby says one thing, Bobby got in trouble.
the failure to utilize an IOLTA account or to deposit client funds in an IOLTA account. And if that's wrong, I apologize. I'll have to refer back to my notes on that.
That's fine. Thank you.
All right, anything else? All right. Ms. Latest, you ready to proceed?
Yes, sir.
You may.
I'd like to first start out with, I'm not claiming I didn't negligently violate any rules. I don't tell you the ones that I know I did. But I definitely never stole anybody's money. I never accepted any money in advance for services not yet rendered. And I'll go through the exhibit and get that admitted in a moment. I definitely did practice California law without a license. And when it had just been suspended for non-payment, I mean, I don't know if it matters, but my husband at the time going through a divorce, abusive, all this horrible stuff, he was ordered to pay them, and I negligently didn't. I avoided it, and that was a horrible mistake. And then I also, on the letterhead, held out that I was licensed to practice law in Texas, California, and Colorado when I was inactive in Texas, and I was again suspended for failure to pay at the same time almost for California and Colorado. And I also failed to give them a timely invoice, and it's horrible. It's inexcusable. I'm not going to say that what I was going through with my kids being kidnapped and all that kind of stuff for all those many, many months was an excuse. I should have just not been practicing. And I made that mistake. I did give really great legal advice, and I think their emails are far from grateful, and they changed their business model. And, so I do believe I did something wrong. I just didn't in any way take their money and steal it from them and in advance, any advance payment. All the services had been rendered, and they had, and I guess I would just like to go into the exhibit A, which, and then submit that into evidence, if that's the proper way to do that. That's the email exchange from August 22nd through 26th.
You previously submitted that?
Yes, sir.
In respondents exhibits? Exhibit A?
Yes.
Do you have any objection, Mr. Humpalmer?
You shouldn't suspend me for being a lawyer, guys. You shouldn't. But how do I get this into evidence? Is this the right way?
Do you have any objection to the admission of Exhibit A?
Pardon, no objections, Mr. Chair.
All right, it's admitted. Exhibit A only.
I mean, in that email exchange, they clearly in August acknowledged that I've been providing them services, asked me to continue to provide them. They reject the advance retainer blatantly and say, no, we don't have that money right now. Could you please continue to provide us services at an hourly rate? And when we can come up with the funds, we will send that to you. And they're happy with me. They changed their business model in that email, and they completely revamped it for my prior legal advice that I'd already given them, and asked me to set up another meeting with them, which did occur. And I told them, hey, it's going to take me, I've already spent a lot of time on this. It's going to take me hours to do that. Is that okay? And I even gave them at least 5 hours to even prepare for that with the new changes to their business model and do the research and everything. They agreed and were grateful and said they'll get it to me as soon as they can. That email, the Attorney Regulation Council refused to even consider it. I brought it up multiple times in the negotiations, and he said, nope, in their affidavits, they didn't engage you until October 27th, and you didn't provide them any services after that, so you stole their money. And he just said, that's what their affidavit is, and that's what they've said. And anytime I try to bring up that email exchange where it's just the opposite of their affidavits, he's like, nope. And he also, all along, he said, the only thing I get is revocation. And even with the stipulation, first of all, he was he of course he refused. I know that I didn't have any money to call them, and if that's their only evidence, like why wouldn't he just call them? I think he made a mistake and filed in that initial interim proceeding. He filed those affidavits and had never even looked at the emails, and because I didn't even say anything about it until after it, and he made a mistake. I mean, he should have known that those were false affidavits and should have questioned them. And I read all the questioning in the record of what he did. He never even mentioned to them, well, what about this exchange? Even after.
So wait, let me get this straight. Abusive, and then your kids were kidnapped, and now the lawyer has false affidavits that they went by? Gotcha.
The fact he never did it. And that, I mean, I don't know what the defense is there, but I just don't see how even the stipulation, I kept saying, look, I need to, can we at least put in there what they said in those emails, that they asked me to provide them services, to continue providing them, and to bill them and take it out of the payment as soon as they can get it to me, and to please keep providing services until then. Obviously it's horrible. I mean, I'll never be able to practice law again, even if I get my license. I mean, that says I stole clients' money, and I didn't. And then, anyway, so, I mean, they got more than $7,000 worth of free legal services. I gave them their money back. I was scared about what they'd continue to do after the extortion, where they're demanding every bit of their money back because they found out I wasn't licensed, and they're going to report it to the other boards. And well, we haven't reached out yet.
And now extortion.
But if you give us all the money back, then we won't do that.
That's right.
And they can't ask for all their money back when they have emails saying, without it being a legal threat, to report me for being unlicensed. And anyway, so I guess I should enter that exhibit of their extortionate emails. That's exhibit C in my exhibits that I submitted. I think, or maybe it's D. I'm sorry, it might be D. A is their email exchange from August, and then B are the affidavits. I would like to go ahead and submit those two. The B, the false affidavits, and then C is the invoice. D, I'd like to submit all of these. D is the extortion emails, and E is just the summary of all the traumatic things that I was going through at the time with the abuse from my ex-husband, my children also being arrested for abusing me, and they were kidnapped by him. And eventually the judge ordered that if he does it again, he'll go to jail. So that finally.
I didn't know Bill had a new channel. No one told me. Somebody tell me so I can say it. Bill has a new channel. Is this American Court 3? Tree 50? Hi, Junebug. I need someone to type in a whole bunch of more words, please. Bill, where are you? What new channel? Can I have a link? Yeah, what happened to his old channel? Oh my God, I did this before with Bill. Remember I said in his last video, blah, 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 blah. And y'all said, oh my God, that's his last video. Oh my God, he's gone. Alright, Bill does not have a new channel. Bill does not have a new channel. Gotcha.
Stopped. And then my mental health records and everything. And all along, when any time I'd ever try to talk about any of it, he would just say things that were completely wrong. The attorney for Colorado, he would.
Kelly, I think I know what you're talking about. Is it the Fleischer thing? I think that's what you were thinking about.
Say, no, there's no way, your mental health history or anything that's happening with the abuse and everything can be admitted. The only thing you can do is hire an expert to speak to that. And then sure enough, when it gets to our status conferences, the judge is like, no, y'all need to, she needs to be able to argue her case, and he ordered mediation. And the mediator insisted, no, of course, all these are mitigating factors. And also he insisted that there should be stuff about what is in that August exchange. But eventually that attorney would never let me put it in there as part of the stipulation of what happened. Anyway, there's the invoice of everything, and they've done this in the past. I should have never taken the client on. One of the clients, he still owed me, I don't know, $3,500 where he did the same thing. Oh, please, I have it in emails where he's like, oh, please keep providing me services and we'll pay you as soon as we get the money and we get funds. And I shouldn't have taken the client on, but that was my fault. I don't know what the right provision under 904 looked like. All of them applied, but I guess not. I don't see how the whole case is based on false affidavits. In their affidavits, they expressly state, we never engaged her to provide us legal services until October 27th when we paid, and she never provided us any services. And that we talked to her before just to see if we liked her. But that's directly conflicting with their express email saying, please bill us at an hourly rate. We don't have the money yet. And I even want to give them time quotes. Okay, sorry. Yes, sir.
Now, let me ask you a question. Why in the world did you stipulate to the sanctions in Colorado if you had these objections to the evidence and a belief in your innocence?
The attorney said, all you will get is revocation if you don't sign this. And if you go to hearing, I'm not going to call those witnesses, and I couldn't afford to get anything. I mean, they're out of state, and I don't have that money. I mean, there was no way for me to do it, and I thought, the emails speak for themselves. I didn't see how in the world it makes it. But he said that no, if you go, you're going to get revocation if you do the hearing. And I've got many emails from him saying that, so it's not like me making that up. But
do you have anything else?
No, Your Honor.
You're finished with your testimony?
Yes, sir.
Do you have any questions, Mr. M. Palmer?
I do, Mr. Chair.
Go ahead.
Ms. Latis, will you explain what the current state of things is with your complaint in Colorado?
The head just said it's tabled. That's all she said.
Do you know if there's a particular timeline that has to be resolved or dismissed?
Not according to them.
Okay, I have nothing further. Thank you for your time.
All right, any questions from any BOTA members for Ms. Latis?
I have a couple. Ms. Latis, do you have a disciplinary proceeding pending against you in California?
No, I notified them and I haven't heard anything.
Okay. And in your response to the show cause order, I believe you raised, a bunch of defenses that probably don't constitute defenses under Rule 9.04, but maybe due process does. Can you identify which specific defenses you're asserting in your response? And if you could just be specific and try to be real focused on exactly what your defenses are without going into what somebody did to you or anything like that. If you could just be specific about what your defenses are, I'd appreciate it. Thank you.
The attorney for Colorado filed a false affidavit that he knew or should have known.
I mean, what I mean is the defenses that are listed in Rule 9.04. If you can't do it, that's no problem. I'm not here to
let me
just to string this out.
Yes.
The defenses that are listed in 9.04. If you could be specific about that, that'd be great. If you can't.
Okay, I don't know that you're banned. I think you should just try to say hi. I don't think that you were. I mean, I don't know anything about it, and I would have known. And Linus doesn't know anything about it, and she would have known So I think there was a misunderstanding somewhere, but no one would definitely ban you. No one. We love the hell out of you.
Yeah, that's all right too. Just can you identify the defenses?
Maybe a little on A, so lacking in opportunity to be heard to constitute a deprivation of due process. I mean, every single time I tried to discuss with him anything
Deprivation of due process.
about the defenses, like the mitigating factors and that email.
Are there any other defenses besides
Okay.
A?
Okay, let me see. There was such an infirmity of proof establishing misconduct in this jurisdiction as to give rise to clear conviction.
You stipulated to that. So what about C, D, and E?
See, definitely a grave injustice for me being punished for stealing a client's money when they asked for services and agreed to pay for them. I don't know how that could be a worse injustice, but
Thank you. And is the misconduct for which you're disciplined in Colorado, is that professional misconduct here?
yeah. So the allegation is that I stole their money, never provided services, and took advance payment for services not rendered.
Okay,
And
so
their emails say the opposite. So
okay. All right. That's good. Thank you.
let me make sure that I haven't hit any others.
I had a hooker conviction like that once, but it was dismissed.
Okay, so E wouldn't apply because it's the same rule and essentially the same in both states.
All right. Thank you very much.
D and E don't apply.
All right, you have a question, Mr. Palmer?
Yes, Mr. Chair, I just had one follow-up based off of member Boatwright's questions. Ms. Latest, do you have any clients in Texas at all, or do you practice in Texas or plan to?
Oh, not until all this gets resolved. I know I don't have any clients in Texas or California or Colorado. I'm teaching full-time as a high school calculus teacher.
Thank you. That's all, Mr. Chair.
Any other questions? All right, do either party have any other evidence or argument?
No, Mr. Chair.
All right, nothing else, Ms. Lattis?
Other than that, I think it's clear and convincing evidence from their emails that they asked me to provide services. They were happy with them. They requested it to be taken out of their future payment, which was not an advance retainer. And by their own designation, they rejected paying up front before anything. And it seems like a grave injustice that if someone can submit false affidavits directly in conflict with their own words and outright lie, and I lose my license.
Kids are kidnapped. While my kids are kidnapped and I'm in a toxic relationship where I'm abused, and then they're happy because no one will look at these emails. So they're going to suspend her for 3 years. They're still talking about it. But she didn't say anything legally that would prevent them from doing so. Okay. So I have 3 more. Just want to make sure I got Oh, I forgot Dolores Umbridge. Hold on, guys. We got to watch Dolores. This... All right, I'm going to put it on and pause it real quick so I can tell you. This one right here. When she smiles like that, she is terrifying. I think I'd be okay in front of all the other judges that I show. But not her. Not her. However, she has this rule that you're about to find out about. That's really, really good. I love her rule. You're going to love her rule too. Here we go.
The defendant in room 2G, you are unmuted. Can we get your name, please? No, if you can hear me.
Sorry, the Dolores Umbridge that we met in the books. looks way different than the Dolores Umbridge that you see on TV in the movies. That's not the Dolores Umbridge in the Harry Potter books had a wide toad-like face, and on top of her head was a bow that's, sort of looked like a fly. I don't know how to. So yeah, toad-like face. So this woman in my head came closer to. Forget it. Never mind. That's just what I called the clip.
Hey, tell me your name.
Tawana Esco.
Esco. State of Indiana versus Tawana Esco, 49D27-2306F5-017010 comes on as an initial and amended violation of probation.
All right, do we have a date set for when he comes to court already?
No, he does not have another court date set.
Okay, raise your right hands. Swear affirm under the penalties of perjury. Tell the truth, the whole truth, and nothing but the truth. Back up a little. I can't see you. Yeah, you're here today. I can see you. State of Indiana has filed a violation. They're alleging that while you were on probation, and if they find you in violation, you could get some or all of your backup time. When you come to court, you can admit, deny, or set it for a contested hearing. You had a bunch of pending cases, like you didn't go take a drug screen back in May. In June, in June, you tested positive for cocaine. Then in June 24th, you didn't test. And then you tested positive for cocaine July 22nd. And then you tested positive for cocaine on July 15th. In August, and then apparently then you failed to report to probation. Nobody's seen you since April. You have an active warrant on your probation in court 36 after you failed to appear for an initial hearing. And so you're being held no bond. Do you understand that?
Yes, I went to court yesterday on courtroom 36. They OR me out on that.
I am not ORing you. You've been testing positive for cocaine. You have 1,776 days that you could get backup time. You are being held no bond.
No, what I'm saying, ma'am, I went to court yesterday on courtroom 36. They OR me on courtroom 36.
Absolutely, that's their prerogative. But I am holding you no bond until the case is over. When's your next court date in 36?
February 3rd.
Okay, court will set this after February 3rd. Do you need me to appoint the public defender to represent you?
Yeah.
Okay, court will set this on February 13th. I will appoint the public defender. I'm not sure they have a rotation for February yet, but they'll let you, your attorney will be in contact with you before court, okay?
Yeah, so I'm still on hold.
Yes, you're being held no bond. Nobody has seen you since July. And no, do not talk. This, because you have a right to remain silent. This court has a rule. You sit in jail for however long you run. That's a minimum. So you've been gone since July, August, September, October. So about 6 months. So maybe next summer we'll talk about letting you out. Okay? If you're found in violation. If you're not, I'll continue you on probation. But they have to prove your violation by a preponderance of the evidence. Okay? I guess he's done with the rights. All right. He walked out.
To the defendant in room 4B.
Yep. That's their rule. Man, I'll talk to you next summer about letting you out. Okay. Now, this made me feel better. When I didn't feel good, this happened. It starts off with this angel singing something.
Go ahead and sign for your reset. All right, Judge, next is page 20. Sanford, come on up.
Oh, then I felt better. I felt better after that. And then this made me feel better too when I didn't feel good.
You were Jessica Sanford. Ms. Sanford, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, ma'am.
Yes, Judge. On September 29th, 2023, officer was dispatched to a disturbance call in Harris County, Texas, and met with the complainant, who stated he asked the defendant to leave his apartment multiple times, but she would not comply. The complainant had video footage of the defendant refusing to leave and mentioning something about darkness inside of him. And the complainant and the defendant were in a relationship, but the complainant had ended things earlier that day. The defendant locked the complainant out of his apartment, and the complainant showed officers an injury on the back of his neck that appeared to be nail scratches. The defendant barricaded herself in the apartment, refusing to leave. So in this case, Your Honor, the injury caused by the defendant, according to the complainant, would be the nail scratches on the back of his neck that he showed.
You say you never told me that an officer said this, that he told this to an officer?
The complainant just showed an officer an injury on the back of his neck that appeared to be nail scratches. Let me read the full DIMS, Your Honor, and see if he mentioned something else.
We don't work on hunches.
Yes, Judge.
I never heard anything that don't, please.
So the full DIMS reads that the complainant advised of an injury he had on the back of his neck area that appeared to be nail scratches done by the defendant with their hands, causing the complainant to feel pain. Yes, Judge. And I apologize for.
Wait, did I see pictures of this in Discord? The scratches on the tiny little scratches on the back of the neck. Speaking of, where's Snoopy? Snoopy, are you feeling better? Snoopy.
Okay. I just want to make sure that we're in the up and up. Ms. Sanford, I'm going to find that there's probable cause to go forward with your case. Do we know whether he wants to have contact with her or not? I know that you want to talk. I've got a bunch of DAs here. Whatever you say, they're going to use it against you. Now's not the time. You will have the opportunity to fight. I promise.
I don't want to fight, sir.
Okay, don't say anything. I know, please. I've got a bunch of DAs here. Whatever you say, they're going to use it against you. Just don't.
We've attempted, but we're unable to get a hold of her at this time.
Okay. So, tell me, Ms. Sanford, are you working at this time?
Sir,
I only want to know, are you working?
I haven't been able to because since I've been arrested, I haven't been able to get a,
I will provide you a lawyer today. I don't want you to say anything. I'm going to give you a lawyer. You can tell your side to the lawyer. Lawyers can talk to the DAs for you. But I've got so many people here. I mean, all these people will be witness to whatever you say, and they'll use it against you to prove guilt, okay? So just hang tight. Give me 20 minutes. I'll give you a lawyer. You can tell your side to the lawyer, okay? I want you to understand, though, I don't want you to have contact with this person because I don't know if they want to have contact with you. They've been unable to reach him. Until that we know that she or he wants to have contact with you, don't. Trust me, I'm trying to help you, okay? I promise. We're not here to do anything bad. I'm going to help you as much as I can, okay? But I need you to be patient with me, all right? Rome wasn't built in a day. Just be a little patient. Let me get you a lawyer, and you can tell your side to the lawyer, okay? Please. All right, so what I'm going to have you do now, I'll have you sign a reset. Just take a seat in the jury box. Let me find you someone here momentarily, okay?
I'm gonna help you. I'm gonna help you, ma'am. Ma'am, I'm gonna help you. Everything I can to help you. And then after the judge made me feel all better again, this happened. It broke my heart.
Oh, perfect.
Hi, how are you?
Doing great. How about yourself?
So Judge, Tristan Smith is back on the docket. He was unable to make bond over the weekend. Some issues with co-signers or whatever. Nevertheless, he's in custody. He immediately asked me about a time served. I told him I didn't like that for him.
I'm not doing it.
Well, that's why I wanted to talk to you, because I figured.
The last thing I'm going to do is we're going to ruin his life by just racking up convictions and just going to take it out. I'm with you, and we won't do it. So
then I would say we probably, if we could, set the matter for trial, because otherwise I don't see him getting out based on what he shared with me and the one person
I need to know if I turn down my headphones, if it turns it down for you guys too. Michael, don't be mean to Donald. Donald, don't be mean to Michael. Alright, I'm going to turn this down. You guys tell me if it turns it down for you too. Because I leave it up the whole way just to make sure you guys can hear, and it's killing my head today.
talk to.
Mr. Brooker, I'm not going to just hold him indefinitely. You know,
I know that. I know, but he had a test today and it's like messed up. And so I'm trying to do what I can to get things moving, because otherwise he's not going to get out. I mean, he's just going to sit there.
I want to hear what happened to Tristan. Did that turn everything down for you guys? Or is the sound still okay? Okay. All right.
Apparently they have the money. It's like $380, but they don't have a cosigner. He doesn't have any adults here that's going to vouch for him. So I'm talking to children about his case, like some 19-year-old in another state is really rich.
Hey, Stephen, do you mind bringing out Mr. Smith, please?
Do you guys remember Tristan? He got kicked out of his grandma's house. His family doesn't want him. Again, Fozzie, I had 2 words to say to you all day.
Marcos, you can talk to me already?
Yes, Judge.
Hey.
Approaching on Mr. Miguel Moreno, is an FSGI judge. The state has spoken with AT&T, who is the owner of the other vehicle. About $26,000. Does not necessarily, I don't think that's accurate, to be honest with you. They have an estimate of $26,000. The state has reached out again to see whether that's what was actually paid by AT&T, which I'd be very surprised.
No, of course not. No. They're loaded with insurance for these kinds of.
So the whole point was, what I'm trying to do is have him pay some sort of restitution and let it go. And I think the state's fine, but they just need to find out, what happened, whether repairs were done.
Yes, Judge. We just need to confirm whether the vehicle's been repaired and what the actual amount paid by.
The problem is how do you do that, right? Because I know that you guys had a problem even trying to get a hold of anyone at AT&T to get this kind of information.
Well, Mackenzie's reached out and she sent an email and they said they would return some sort of response to her, but as of now they haven't.
So why don't we set it for Monday?
Okay.
Hopefully, you can try to get a response. Good luck. I know that it's been an issue in the past.
Go from there.
Yeah.
Okay, sounds good, Judge. Thank you.
Judge, is that a waive appearance or required?
Yeah. I mean, there's no sense in bringing it down here. How's jail?
113.
Mr. Smith, we want you to be the best person that you can be, right? And part of what you need to do and what we're here to do is teach you how to grow up, to make better decisions. You have no one that's going to bond you out. These are things that you think about when you go out. If you are hanging around with thugs, people will treat you like a thug.
You left your TV on before you left for Texas, and I can't turn it off because I missed you, and now your TV is just on 24/7. Don't do that again.
Perception is reality. These are things that you think about when you're out there, whether you're going to a party, whether you're hanging out with other friends who like to smoke weed, whether you're going to a park and you know that there are people that are not good for you and you're still doing that. These are decisions that you need to look at and to think, okay, if I do this now, what potential bad things can happen? I'm on bond for a criminal case and I don't have anyone to bond out. I got a test on Monday, yet when you're out there, always consider the negative of what can happen in every decision you.
Oh no. Anthony, did your coach show you my text messages? Did your coach? Oh, hey guys, Anthony might not know.
Make. You are now in jail. You've missed a test, allegedly, because I don't know for sure. You could be blowing smoke on my public. I would never even know, right? Am I supposed to feel sorry for you now that you have 2 assaults? You just doing your job. Right. But what I want you to do is I want you to learn. And you got 2 assaults and you still haven't learned. So what do we do to ensure that you now, if we let you go out in the street, you're going to make the right decisions? What do we do? Because I don't know. I want to let you in. I don't want to keep you in. But you're your own worst enemy. If I let you out, I know that you're just going to continue to make a bad decision. So we're in an impasse. It's a dilemma. It's a fork in the road.
Situation is a little different today, Judge, after a weekend in jail, seeing how easily Mr. Smith can lose his liberty if he is not 100% compliant with bond conditions. He hasn't just heard it from us now, he's actually experienced it. So that's different. And I would think that matters to him as he understands how quickly things can change in his situation.
How many times have we put him in jail?
It's only the first time, Judge.
We tested him.
Revoke his bond once, am I not?
No, I don't think we were any bond revocations.
Mr. John.
No, we appeared initially and he had a drug test and we had a conversation. You admonished him, but this was the first time he actually went in.
And how many violations have we had?
There was only the one dirty UA, Judge. At least that we spoke about.
Here's my other. If I were to go send you for a drug test now, what would pop up? It's a rhetorical question. I don't want you to answer. But that's what I'm also thinking about. Me, you're in jail. You picked up a new case. I've repeatedly asked you to not smoke weed. You've tested positive already once. If I send you for a test now, what's going to happen? I don't know.
All of that before he had to go to jail. Now he sat in jail and can't get out. There's no way for him to get out. He understands that. So I would think that would change his mindset. He's intelligent and he understands, but still 17 years old has to sometimes hit their head to learn and understand what those consequences really feel like.
Where are you living now?
I still with my best friend in Uncle, Timber Forest. I just started staying there 2 days before I came to court.
You may even have a stable home.
Well, the order and the request of the state was to stay away from grandmom and don't go there and don't ever go back. So he hasn't.
Have any other parental figures out there?
Sir, I don't really know too much about my family. Yeah, just pretty much, I don't know too much about my family. They really don't want nothing to do with me. So I just be,
And just somebody that purported to be Tristan's mother did reach out to me, but indicated that she could not help or didn't want to help because I asked those questions too. Wasn't
take him in?
No, sir. This was about 2 or 3 weeks ago. So he's truly on his own. And again, the person I've been speaking to purports to live in Georgia and is young himself. Can't come here, can't do anything here. So our hope was that he was able to make bond because it is reasonable. It's a reasonable amount of money, but the bond company won't bond him out without.
But even
everybody over the age of 12 knows how to use that.
Mr. Brooker, even if you bond out, if you continue to make the bad choices, you're going to end up right back here over and over and over. He's telling me that you want to plead guilty just to get out. I'm not going to do that because I'm not going to let you ruin your life. Because when you end up with these assault convictions, you're all but ruined. Do you think people hire assault convictions? You think you're going to get a job? You think you want to go to school to study this and that? It's all for naught because when you start racking up convictions, life is hard enough as a black young man in society today as it is. And when you start racking up convictions, it only makes the life more difficult for you. That's hard enough as it is. And you're not getting it through. If I go drug test you now, what is the result? Even after months of me preaching to you not to use. I don't want you to answer the question. What I'm trying to break through to you is that I have repeatedly told you not to use. I've repeatedly I've told you not to hang with dogs because you're going to get fleas. And not you caught yourself a damn flea. I don't know. I want to let you out, but I can't trust you.
So where we are with it now, Judge, state made the offer. We understand your position on it, which I thought that would be the case, that you wouldn't accept that plea. So I'd like to move forward as quickly as we can.
Who is the best friend that is you're telling me that you were going to stay with? How old is this person?
She's 18.
And who does she live with? On her own?
No, she stayed with her mother. Me and her mother had a talk about me staying there. And she said that as long as, I do what I continue, well, she said as long as I continue to, keep up with my schoolwork and stuff and, keep on the school. She said she just don't want to go near her house. So as long as I continue to go to school and stay out of trouble, then.
Oh, I hope that's true. I really, 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 really hope it's true. It's not, guys, but I really hope it's true that his friend lives with his mother. I don't think it's true because I think, 7 minutes ago, he said that she lived with the uncle. But I could have maybe I heard something wrong. Okay. I got a game for us to play. So let's listen to Tristan for another minute, and then I got a game for us to play.
I'm good there. And she understands that
If I can verify that there's a parental figure at that house, I will let him out. I'm going to put a monitor on you and I'm giving you a curfew. But if you can somehow verify, Mr. Brooker, that there is an actual adult living there, it's not just an 18-year-old just hanging out, 17 and 18-year-old, then I'm down. But I got to know that there's some kind of adult figure there so that we know there's at least some kind of supervision, not two 17 and 18-year-old hanging out with each other, because that's a disaster in the making. I don't want any more disaster. So if you can verify that, I'm down. But I'm going to tell you now, you will be reporting here to me while you're on bond, and I'm going to test you on a weekly basis to make sure that you're not using. The next time you test positive, so help me. Do you understand? You pick up a third case, I'm going to lose it. And the little hair that I have left will be gone, because that's how upset I will be. Do you understand? Don't smoke weed, and I want proof that you're enrolled in school full time. Do you understand, Mr. Smith? The only way is that I know that there's a parental figure here, so you have at least some kind of someone watching it. Okay, so we got time. I mean, I'm here. You have my cell phone, right? So just text me, and even if it's 2 o'clock, 3 o'clock, we can work it out.
I'll work on it. Thank you, sir.
It's been over 40 days.
Okay. All right.
We remember Tristan from before, Anthony, and it's been over 40 days. Okay, guys, let's play a game. I got one more clip to play, and it's not very long. It's very short, actually. So the stream is almost over, but I got homework for us between now and tomorrow's stream. All right. This is that wish list on Amazon that people were putting, like Snoopy. There's still like a Snoopy head on their plant pot or whatever. It's not a real wish list. It's just I don't have a P.O. box anymore, so if you wanted to send something, you send it there instead. Anyway, we're going to use this. We're going to use this wish list today. So between now and tomorrow, put something on this wish list that you think Fozzie would love. please make sure it's appropriate, because I would like to show the wish list on my stream tomorrow. But I can't if you guys fill it with inappropriate items. Put something on this wish list, or 10 things, it doesn't matter, that you think specifically Fozzie would love. What do you think Fozzie should do with his spare time? What do you think Fozzie should eat? What do you think Fozzie should dress like? What kind of steering wheel cover should Fozzie have on his car? So think about Fozzie's life. What kind of slippers should Fozzie wear? Everybody, everybody put what you think Fozzie should want on this wish list. And tomorrow we're gonna see. Tomorrow we're gonna see what everybody thinks Fozzie should like, and this is gonna be so much fun. This is really gonna be so much fun. All right, I got one more clip. Oh, Junebug, thank you so much. Yep. I'm trying, guys. There is one more. I just have to find it. Okay, here we go. It's real short. This last clip is very short. Hi, Ardo.
You tested negative.
Well, thank you.
That's fantastic, and it makes me very happy. So look, just be good. That's all we're asking, okay? Nothing's going to happen to you today. We'll just give you a reset and just be good. Don't pick up a new case.
Honor. It's very tight. I'm not a flight risk. I'm not going to be, I won't go around that area. Me and everything else. And
You tell me I can trust you.
yes, you can. Judge.
I know. I saw it.
And it's really cut, like it hurts. It's like they put it real tight to the point it's like getting into my ankle.
Corey.
Yeah. Yes.
Take it off.
Thank you.
Just be good. It's not hard.
John Love, I am so sorry I got sick at the worst possible time. I think about you every day. I hope that you're doing okay. I hope that you're making it 1 minute at a time. It sucks, John. I mean, it sucks. I am so sorry.
Make the right decision when you're out there. You pick up a new case, a third case, I'm going to lose it. You understand? Just be good. Talk to Corey. He's going to help you out. We'll take it off now. Okay?
All right. Well, the evidence was we able to run the hearing.
It's going to take.
You and I will talk about that. Yeah.
Okay.
Simmons Urban, it takes time. I mean, they got to talk to the people. They got to get it. It takes at least 2 weeks.
Okay.
But don't worry. Don't go back.
I won't do it. I won't go back.
Be good.
I will.
All right. Take care.
Thank you, Judge.
So it does I get to go get it off, right?
Yeah.
Okay, right.
So we got to see Savsit Girl, and we got to see Tristan. And Savsit Girl, who we would think would be on a spiral straight down, is doing fine. And Tristan, who we would have hoped would have been in an upward trajectory with some kind of stable place, no more assaults. The judge was right. He did violate his bond. We saw Tristan come back again because he tried to go home. He picked up another assault case. And I understand where the judge is like, I can't let him out. He's just going to pick up more cases, and soon they're going to be felonies, and then there's not going to be able to fix this. But yeah, that was Bizarro World there. Anthony, good luck in your tournament. And not your girlfriend. Brent, that was the address to the Houston County Jail. No, I have to work today. I work today. Okay. So I'm not gonna be able to do OJ today, guys. I gotta go back to bed. Thank you so much for coming out today. I'm sorry I was off the last 2 days. But I shall be back tomorrow. Don't forget, oops, I lost the link. Scroll up, there's a link up there. Don't forget to add something. Yeah, no, I wonder why, Anthony. Yes, I know a lot of you are also sick. And oh my gosh, all the comments I got. Thank you so much. I couldn't reply to them because I couldn't lift up my phone for that long. But thank you so much for your comments because I know you guys were all sick too. No OJ today. I'm going to bed to drink some OJ. Your comments were awesome. They made me feel so much better. Thank you. And I hope all of you, just like you, Nan had a stomach flu. I hope you guys get better too. I hope your snow goes away and comes over to me. And I shall see you all tomorrow. Thank you hi Becky. Thank you so much, guys. See you tomorrow. Love ya.
Got these lights that goes digital dreams through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Freedom tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Her eyes hear a sky so blue. In her jokes, there's a truth so true. Wicked stream, she brings the light. Turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a wake, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle.